I also perceive, though, a difference between like Justice Scalia and Justice Thomas's jurisprudence, for example, in terms of looking at stare decisis. Like, I think that if you're like a Justice Thomas type originalist, you're going to say right is right, wrong is wrong. If a case comes up before me and it was decided incorrectly because they were reading the Constitution wrong, I'm going to vote to overturn it. And I think Scalia's originalism is a lot more it's less heavy-handed in that area, let's say. Like, I think he's going to say it's still wrong. We're going to agree the decision is wrong, but the question is whether we should overturn it, and that's a separate analysis. And
this was a difference that we had. Actually, I remember this. Yeah.
Yeah, and I think that it mattered in that debate because your version of originalism, which I ascribe to Thomas, but that's how I read it at least, would require that you ground the parents' right to have their children raised in their religion in the Constitution itself to answer the question. And for me, I just had to be like, well, there's a case on this. Yoder, it's good law. Like, I don't need to run it down to the roots because nobody's saying we're overturning Yoder. So what are we talking about? There's a case on point, right? And I think that's a meaningful distinction within originalism. I don't know if I answered your question, but I think it's certainly a big one.
No, it does. I think that's a fair. I think that's a fair analysis. I think that, and honestly, I would agree. I think that you probably do fall more into the Scalia camp. I probably do fall more into the Thomas Alito camp. Honestly, I think that a great example of a case where this sort of like kind of historical understanding and analysis comes into play is Dobbs, right? Which is penned by Alito, and he goes through and he points out, he goes through the history of, hey, look, the same people that wrote the 14th Amendment were the same people who were banning abortion. There's nothing in the 14th Amendment that would even hint at, this weird 3-trimester framework. But how could you possibly think the people who were drafting this, the 14th Amendment, would then, within the same, period of time, 20 years, they would go on to ban abortion in almost every state, right, in the country. This is what happened in the late 1800s. It's not historical, and it requires massive leaps of logic that just simply don't fit the historical record. That's what I find to be most persuasive. I also do kind of find, if you have bad case law, right, because Dobbs did overturn bad case law, Chevron got overturned, right? I think that's was bad. There have been instances in which I don't think that the length of time. Here's a great example, like Wickard versus Filburn.
That's exactly what I was going to ask you. Wickard versus Filburn.
Yeah, or Korematsu, right? That's a more optically, the one putting Japanese people in camps. I think that was decided pretty bad. I think that was decided wrong. I don't think that was constitutionally justified. And even the decision really just starts talking about how, like, it was wartime, etc. They don't really try to constitutionally justify what happened. And Wickard versus Filburn is just constitutionally horrible, right? This idea of, well, technically what they meant by interstate commerce is anything that could potentially affect interstate commerce, which includes all things within the state, even if they don't leave the borders. And we're not going to apply any kind of substantive test to this. It could be literally anything whatsoever. That's just, it's crazy. And we're seeing a little bit of limitation on that now, but yeah, I think that should be overturned. I'm okay with bad case law being overturned.
Yeah,
and that's kind of my school.
A little just for the non-lawyers, because we're now officially speaking in code. Korematsu, and I think Lactoid did a good job with this in context, but just to make sure, Korematsu is the decision that said that it was totally fine constitutionally to put the Japanese in internment camps, during World War II. And then Wickard v. Filburn, which we talk about on this channel a lot, is the case that is why the federal government is no longer a limited government anymore. It basically says that they can they're supposed to only be able to regulate interstate commerce, but because it said that all commerce is interstate commerce, they can now regulate anything that happens in the country in any place for any reason, flat stop. It is probably the worst decision, at least for me, in the modern jurisprudential corpus. Like, it's really, really bad. Especially when you realize that it only came out that way because FDR was threatening to pack the court, and the stitch in time saves nine. Like he was going to court pack and just do whatever he wanted. So all of a sudden, all the judges who were ruling against him changed their mind and started having just completely batshit crazy opinions in the opposite direction. So not only is it like a bad decision, it was made for terrible reasons, right? And that Wickard is a tough one for me because I would really like to overturn Wickard.
And there's a lot of case law that is based on Wickard.
But that's the problem, right? And so I'm not trying to say that like Scalia or Thomas have a better version. Overturning Wickard would be a lot easier for a Thomas disciple. For me, I would have to work through the various factors that he found important, like how long has it existed? That's only one of it. How bad was the decision, which is another part of it. That one was pretty bad. Like they had, what's the phrase he used? They had to have known they were lying when they wrote it, right? Like, I mean, like if there's truly awful decisions. But the other problem is how unworkable a standard has it created. Wickard's not an unworkable standard. It's a very workable standard. It's just a wrong standard. Yeah. So Wickard would be very tough for me. Like if I was on the court, I would probably find myself in the position of having to chip away at Wickard, rather than like kill-shotting Wickard. Like, and for those who don't read Supreme Court all the time, a lot of the time, if a justice is in a position like that, where they're like, we can't overrule this, but we hate it, they'll just keep limiting it. So a case will come up and they'll be like, do you want to overrule Wickard and say that, in fact, farmers who don't sell out of the state are not subject to congressional regulation? And they'll say like, well, we're not overruling Wickard, but we're going to say Wickard doesn't apply here, and just kind of set up breadcrumbs so that new cases can come and they can keep chipping away at it. But like, there is something satisfying about the Justice Thomas approach, where you're just like, no, root and branch. We're going to take the whole thing out. The counterpoint is Marbury v. Madison, by the way, because Marbury v. Madison probably is not probably does not pass muster under originalism. It probably doesn't. I've
heard some arguments.
I haven't deep dived it, but they didn't have judicial review for a while. Like when they passed the Constitution, there was no judicial review. Suddenly there was. So, but the argument for the Scalia version of originalism is like, let's say someone comes to court and they're like, I want to overturn Wickard v. Filburn. And I go, wait a minute, Wickard v. Filburn? Does the court even have the power to review this decision? And they're like, yeah, Marbury v. Madison. I go, well, was it right? Like you can't, you have to rely on stare decisis at some point. Like the legal system just doesn't work if you relitigate every case every time. You know what I mean? Like there has to be a foundation you can build upon, and the law just needs stability, which is why I favor that position. But it's not that I don't understand the alternative. It's just kind of these are legitimate differences within the philosophy.